started. Hi, everybody. Thank you so much for joining us again today. My name is Michelle. I am from Consolidated Planning Group, and we have another fantastic webinar for you today. We're going to be talking about when you're going through a divorce and you have a child with some sort of intellectual or developmental disability, what you need to know in order to make things go more smoothly through the process and make sure that your child is protected. A couple of housekeeping items before we get started. We are in webinar mode, and that means that we can't hear or see the participants, but we do know you're out there. So please, if you have any questions or comments, we love that. We would like for you to put those in the chat box. That's the easiest way for me to keep track of what questions we have as the speakers present. And I will be bringing up those questions to them as long as they're relevant in what they're talking about. And if not, I'll just wait till the end. And if you have a question that's a little bit more specific, maybe you don't want to share with the whole group, we are going to give you everybody's contact information so that you can reach out on your own at a later time and get those more nuanced questions taken care of. So we should be here for about an hour today, and we are recording this webinar. Afterwards, you will receive a link in your email to the YouTube version of this webinar, and you will also receive the slides. So any links that are clickable, you'll get those later on. You'll be able to click on those slides. So again, I'm Michelle Morris from Consolidated Planning Group. We are a financial planning firm, first and foremost. We've been in this industry for over 30 years doing securities and life insurance and investment, just a full range of financial planning services for families. Now, the reason that we have decided to turn our practice to focus on families who have kiddos with a disability is because the owner of our company, Allison, out of the 4 children she and her husband share, 2 of them have disabilities. And so when she was going through all of this and learning about the benefits and how to plan for the future, she realized how difficult and confusing it could be, even for somebody who is in the financial services industry. So she decided at that point to make it easier on the families that we work with by providing free resources, information, and education. We have been doing this, like I said, for over 30 years. We are members of the Special Needs Planning Academy, and we're also National Social Security Advisors. So no matter what questions you have related to planning for the future, we have got you covered. Families come to us for things like protection plans for the future, lifetime care planning, transition planning, ABLE accounts, and advocacy. Over 263,000 financial advisors work in the United States, according to the Bureau of Labor Statistics. And out of those 263,000 financial advisors in the United States, fewer than 0.1% of all of them focus on special needs planning. That's less than 200. So you are definitely in the right place when you are talking with Consolidated Planning Group. And that's why we are bringing Ann Hughes and Mike Day to you today to help present some information that we are not specialists in, but they are. So we're sharing their information with our audience today. We know that it keeps you awake at night thinking about who is going to take care of your loved one when you no longer can. And our advice to you on that is to plan now. It doesn't matter really how old your child is. It matters that you start planning now. And it doesn't matter what you've done in the past, unless you're completely finished. We're not going to make fun of you, or you're not going to be in trouble for the planning you haven't done yet. We're just going to look from now and go forward. We want you to think about what's going to happen after high school is finished. You don't necessarily want your child to graduate to the couch to play video games. So think about the educational, vocational, and residential options that are available to your loved one. And check out these communities and these programs because they could have waiting lists that, might be long and, you might not have immediate availability for your favorite situation. And my last bit of advice for now is to just make careful considerations before you just assume that a sibling will want to or be able to step into the role of caregiver for your individual. Perhaps that sibling will have their own family, their own loved ones with whatever issues that they might have. They might have their careers. They just might not feel ready to take on that role. And your loved one who has the disability could also feel a little bit of a sense of resentment if a sibling is now trying to step into the role of caregiver. So just be careful and don't assume that that's the way it's going to be. You can talk to us for a lot more information about planning for the future for your family. But I want to turn the wheel over now to Marianne and Mike, who are going to go through what you really need to know if divorce might be in your future. It's quite common in this industry and in this community to see families that are getting a divorce, and it can go, it can be a great thing for your family. It can be a sad thing for your family. But I think with the help of Marianne and Mike and Consolidated Planning Group, we can definitely help you prepare the best that you possibly can for that. So I will let you take it over, Marianne.
Thank you so much, Michelle. Appreciate your introduction. And as you mentioned, all those things that you described are all things that we need to think about as part of divorce. And so, yeah, we're here to talk about some of those things as to how to integrate those into your special needs divorce planning process. And Mike here is an expert on the legal side. So I'm not a lawyer. I'm a divorce coach, meaning I help people navigate the process, get through the overwhelm, and figure out how to plan for the future, as well as through the divorce, kind of get them from the emotional side of divorce to the thinking about it as a business and legal transaction, and how can we get through it in the best possible way, like Michelle described. And I'm so honored now to be seen as a thought leader in this field, one that I helped actually kind of create. But it wasn't always this way. I know when I first started, I was overwhelmed with the whole idea of divorce. It wasn't something I was expecting. I didn't know where to start. I didn't know what the future would hold for me and my kids, and how to get the best result for myself and for my family. And so I imagine if you're here, you probably have some of these same questions and not really sure what's going to happen to you and what you need to do next. And so Michelle mentioned this could go, different ways. It could be a positive experience, or it could be one that's very stressful. And divorce is not something that we, enjoy going through, but there are ways to make it better so that we get through the process and have a good outcome in the future. And so a little bit about me. I'm a mom of two young men now on the autism spectrum, opposite ends. And so when I faced divorce after 21 years, I didn't know what to do. It wasn't something I saw on my horizon. And so I had to figure out on my own how to get through it. At the time, I didn't know about divorce coaches. And so I had to figure out resources to help me. So I spent so much time, money, and effort trying to figure out what to do and how to receive the best outcome for my kids. My focus throughout the whole process was, how can I help my kids through this so that they have a good result in the future, and security and safety, some of the things that Michelle described, but also emotionally in other ways as well. And so eventually I did get a good result for my family. But it took so much effort. I didn't want other people to have to recreate the wheel every time somebody is going through divorce. And as Michelle mentioned, it's a very common occurrence. I've seen numbers as high as 87%, as quoted by Psychology Today, of the rates of divorce of families with a child with autism or other disabilities. Some people may argue that number, but it's a high number nonetheless. And so I'm here to help people navigate the complexities of divorce and help them through the process. And so what I did is I created my company, Special Family Transitions, right after my divorce was final on the dotted line. And so to provide special needs divorce consulting and support to families like mine who have kids with disabilities and trying to figure out their next steps. And so honored to be one of the very few certified special needs divorce coaches now, helped inspire the program, and actually one of the instructors in that program as well, to try to get more people who are certified divorce coaches knowledgeable about what it takes to support families going through this transition. And also recently became a mediator, so I can help not just as a divorce coach. I work usually with one parent, but as a mediator, and also became a parenting coordinator, I can also work with both parents who are maybe on the same page or trying to work through some issues to try to come up with a good solution and get through this together. So either way, happy to help out. So I can help before, during, and after divorce. Ideally, if you know divorce is on your horizon, then I can help you kind of get in the right mindset and plan for things that you need to do. If it's during the process, which a lot of people come to me that way as well, if there's some high conflict issues or things that you need help with, happy to help out. And even after divorce, in terms of how do we work with our parenting plan, how do I support my kids and do their schedules, whatever it might be. So happy to help out anytime. And so all this knowledge from my personal experience as well as working with families. And so I decided not everybody can maybe hire a coach or have time to do that. So I condensed my biggest learnings into a course I put together. I called it Keys to Success in Divorce for Moms, children with special needs. It's good for dads too, and also for professionals to learn about the key areas to focus on. And so what I'll do in this presentation is kind of go over some of the points that I came up with to kind of show you the best practices in divorce. And so I came up with an acronym called RISE, because for one, it had special significance to me in terms of rising above and doing your best in the process and being your best self, which we want to do during divorce. But also each letter stands for different things that we want to do in the process. And so I'll take you through each one of those briefly. Okay, and the next slide. So for R, is to recognize and resolve, meaning we want to get in the right mindset to focus on what we actually need to do to advocate for ourselves and for our children in divorce. This is not a time to give everything over to somebody else to make decisions for us. Sometimes we forget maybe how strong we are and that we have the capabilities to make good decisions. So definitely we're our child's best advocate, and we need to relay that to the professionals that we're working with in terms of educating them for our particular situation. Every child with the disabilities presents differently, and so each case is going to be a little bit different in terms of how to get through that. And sometimes people are faced with the grief cycle and maybe don't really want to accept that this is happening. Sometimes it affects different parents in different ways. Some people may be in denial of the disability as well, and that is a whole nother layer. But recognize that this is actually happening and then take steps to get through that. So you're going to go through these steps, first denial, anger, bargaining, depression, and then finally acceptance. And it takes a while to get to that phase sometimes, but when we get to that point, that's when we can actually make good decisions and make progress in our divorce and plan for our future. And so the goal is to resolve to get the best outcome for the future. And then for I, we want to identify and investigate. So basically figure out where we are and what we need for the future to address our child's current and future needs. Because a child with a disability is most likely not going to be independent at 18. And so you got to figure out how to plan for their future needs. But you want to get a snapshot, like Michelle was talking about where we are now in terms of what are your assets, what are things that you can use to support your children. But we also got to figure out what they may need in the future, especially if they're not going to be independent and maybe ongoing supports, what those supports look like and how much they cost. So you want to investigate what those are. There's people who can help you definitely do that, but you've got to get an idea of what your child may need on their worst day. I mean, granted, we want to hope for the best, but we also have to plan for the worst. And so we want to figure out what that might look like in terms of programs that are out there or services and how much those might cost so we can plan and make good decisions and have those discussions as part of the divorce process. And then this is covers self-care, support, secure your team, and special needs aspects. And so I know it's true for me, it was for me, and it is for a lot of special needs parents, that we put our kids' needs before our own, and sometimes we don't take care of ourselves. We don't do things that we need to do to put us in a good position to make good decisions. And so we have to take care of ourselves, and that may look different for each person, but know that you're important and that you can't pour from an empty cup. So be sure to take care of you, do what you need to do to be healthy, and be there for your kids so you can think clearly and make better decisions in divorce. If you're running frantic and not taking care of yourself, you're probably not going to make good decisions, or maybe make something you might regret later. So we want to think things through and be in the best position to do that. And so, yeah, it's hard to do this alone, and we do get overwhelmed. So definitely seek support from family, friends, professionals, and groups. There's so many online groups, in-person groups that you can get to for support. So definitely, yeah, don't hesitate to reach out. Some people are hesitant to talk about their situation, but really by getting it out in the open to those that we trust and that can help us, we're going to make more progress that way. And so there's a lot of professionals out there who are involved in divorce, but we want to find some that have experience with special needs cases. And that includes the legal side, finding attorneys, whether it be a family law attorney and also estate planning attorney, financial people like Michelle and Consolidated Planning Group, certified divorce coach and special needs like myself to help you through the process along the way. Be there to kind of cheer you on, and I'll support you for things that maybe don't need to be discussed with an attorney per se, but getting prepared also for lawyer meetings and other meetings as well. And so I'm not a mental health professional, so definitely reach out to mental health professionals to help you in terms of trying to process some of the concerns and issues you may have. And so some people wonder, what's the difference between a divorce coach and a mental health professional? And so usually mental health professional will help you kind of look at what's happened in the past to get you to this point. But as a divorce coach, I'm present and future focused to help you get through the process and get through, get plan for the future.
Oops.
Okay. And then I see a question pop up, but I'll go through the slide and we'll take some questions. And so in terms of special needs considerations is we want to make sure that we're supporting the child. So, we're planning a lot for the future and financial aspects, but let's look at the child and what they need in terms of routines and schedules and supporting them in that way. One thing I did for my family, because it was really hard to find people to support them, to help them through that, is I created a social story. So a lot of people may be familiar with that if you have kids with autism, but basically to explain what was happening to the family so they could become familiar. And I put pictures in there of what the schedule was going to look like, what looked like at dad's new place. So they will be not as anxious and not as scared about what was happening to them. We want to do this in a loving fashion. Hopefully both parents are still going to be involved, but we want to show them that their routine is different, because that's a lot of times change is difficult anyway for some of our kids. And then we want to plan for their short and long-term needs, as I mentioned before. People just think they want to get through the divorce and then deal with other stuff later. I'd have a different approach, that we want to think about those things as part of the discussions, so that we don't have to go back later and have some conflicts later when we could have addressed it as part of the initial discussions. And then we want to talk about how to fund the child's needs. It could be child support, it could be how assets are divided, spousal support. Michelle mentioned life insurance, and the government programs also can play a part. And so it's important that we set up, as I mentioned, first and third party trust to protect the child's benefits, so that they'll be eligible for benefits. There's a $2,000 cap in money they can have in their name. And so Mike will talk a little bit more about trust, but also know that a lot of people don't know that child support in Texas can extend past 18. So, and it can be above guideline as well. So keep that in mind as you're going through that. And then for E, the last letter in my framework is how to express yourself in a confident, professional manner. So sometimes when we're going through divorce, we may be angry, we may say things that we can't take back, and we don't want to do that. So we want to come across as professionally as we can. There's a gentleman who started the High Conflict Institute. His name is Bill Eddy. He has lots of great books on this topic about high conflict divorce and also how to communicate well in divorce. And his framework is called BIFF, BIFF, stands for brief, informative, friendly, and firm. So we want our communications, as much as it may be hard to, but when we're talking to our soon-to-be ex-spouse, or even with our professional team, to try to adhere to these principles. And then we want to take action on our goals. Sometimes it could be so overwhelming what we have to do in divorce. So we want to do it as a manageable action plan, kind of like a project, and just take one step at a time. And so you can involve others to help you get through that. Definitely, as a divorce coach, I can help you create your plan and help you take action on your plan and your goals that you have for your future. And then the last one, and this important one, is that the divorce process, it may seem like it takes forever, but it eventually will come to an end. And so we want to start looking at the future and embrace the opportunities and the future things that are ahead of us, that for us and for our kids. So sometimes we think of divorce as an end, but I've learned to look at it as a new beginning, an opportunity for growth and for things that we never even imagined possible before. I see there's some, so I'll go through this and then we'll answer the questions. And so, some of you may know me. I try to be visible on social media, kind of sharing tips, sharing these events that I do. I was actually featured just today, posted about in Voyage Houston as my kind of lemons to lemonade story about how I overcame my challenges. And so I share information on my Facebook page, my personal one, which is Ann Hughes, my Special Family Transitions Facebook page, and I also have a YouTube channel where I mentioned that social story video you can find, as well as lots of other resources as well. I have an Instagram and TikTok as well. Also LinkedIn, you can find it under my name, Ann Hughes. And I do have a private group that will be more active in the future, trying to support people that maybe don't want to post in my main page. But also, feel free to reach out to me anytime at my email address, maryann@specialfamilytransitions.com, and my website has links to all these things. So definitely happy to help out and help you have direction in your process.
Yeah, I want to leave this up for a couple of moments so that people can make note of how to get in touch with you, or they can click on that QR code, whatever it takes, while you answer that question, or the questions, depending.
Sure, I haven't opened the chat, so I don't know if you want to read them to me or should I read them?
Yeah, do mediators have conflict of interest issues? For instance, if they know one of the parties, do they get hired by one of the parties or both parties? How does that work?
Well, yeah,
go ahead, Mike.
there potentially are, and they have to be disclosed. In fact, there was a case where a couple of years ago where the lawyer for one of the parties had sent an email to the mediator, who they were waiting for the mediator to arbitrate some drafting disputes. And they're like, the lawyer made some pretty innocuous comment like, we've known each other for a long time, or, and the mediator arbitrated the drafting issue, and that was ultimately reversed by the Court of Appeals, because they found that even though everyone had known that mediator, and both lawyers involved had known the mediator for close to 30 years, right? So you can argue about how ingenuous or disingenuous the argument was made by the loser of the arbitration. But the Court of Appeals said you didn't disclose that, and that set aside. I'll never forget one of the first special needs cases I did. Someone accused me and the mediator of being in cahoots and tried to set aside the arbitration award on some of the issues pertaining to the special needs finding that everyone had stipulated to. And it was crazy. Had to go down to, it was a brand new judge, had to argue in front of the judge, and ultimately the judge said there was, nothing there. But that is, I didn't mean to cut Mary Ann off, but I mean, that's more of a legal question. And so what you'll find most of the time in mediation agreements or agreements to mediate is that people have waived the disclosure of any conflict. And so that is probably the best way to get around that.
Right. And I would also add the intent of a mediation and a mediator is to be an impartial, neutral party. But you'll find that the legal community and the family law community is, pretty tight knit in a way when people know each other. So it may be a lawyer knows the mediator, a mediator knows the attorneys, and so on. That's why I mentioned. Yeah, go ahead.
That wouldn't be very uncommon, I don't think, for, attorneys to know the mediators. But what if it's a case where the husband is friends with the mediator or something like that?
That probably wouldn't be the best choice to make. So definitely you both have to agree. And the other thing, but that was part of the question is, do you have to agree? And yeah, you both have to agree on who that mediator will be. There's sometimes a lawyer, if you're working with a lawyer, will present several mediators, and then they can help you choose, or you then do your research and choose on that. So in terms of payment, usually there's a fee to each party for mediation. And so you can come negotiate as to how that can be handled. But also don't forget, and I kind of didn't realize this in my mediation, is that not only are you paying for the mediator, but you're paying for your attorney's time and all the other team members that may be there during mediation. So mediation is not an inexpensive process, depending on how it's handled. Now, there's sometimes people do mediation without attorneys, and that's something you can do even initially. Like right now, I don't have, like, I'm not a lawyer, so I don't ever try to play one by any means, but I can help people have discussions. It may not be final discussions in the MSA, but I can help people, come to some basic understandings and agreements, and then they can take that to an attorney to write up things like that. So yeah, and so
even if you do use a mediator, you have to have attorneys draft the final order and all of that still.
Right, there's different ways to go about that, but yeah, certainly it's going to have to go through a whole process, through an MSA, a divorce decree, and then the judge will sign off. So there are several steps in that, and that's why I mentioned, if someone works with me as a divorce coach, then I can't be a mediator, right? Because then I won't be impartial. So it's either, think if you want, if you are interested in a divorce coach, that's great. But if you'd rather me work with both sides, and that would take a different kind of role, and that would be impartial at that point.
Okay, and then there is one other question, and then we'll go on. Child support. If there is child support beyond the age of 18 for your child, that is going to have to be redirected to a first party special needs trust, because that money belongs to your child. That's just how it works. Mike, do a lot of attorneys know how to do that, or does that require someone like you who is more nuanced?
Well, in terms of the family court judgment, I don't know that a lot of lawyers really know how to do that. In terms of drafting the trust agreement, I mean, that's not something that I do. That's something that you would need to see a kind of a specialized estate planning attorney for. And it's something that a lot of estate planning lawyers, a lot of very good estate planning lawyers, if they don't do this work on a frequent basis, they may not be the right fit, honestly. It really is kind of a sub niche, and there are all kinds of competing considerations. Medicaid changes its policies every so often. So you need someone who is dialed in with what's going on in terms of the federal government's regulations of these sorts of things. And I saw someone ask, can the child support get paid into an ABLE account? I don't know. I would be very leery to do that. I wouldn't do that. It needs to go into a Medicaid payback trust, which is a first party special needs trust.
Right, exactly. All these things are why you want to work with professionals who are experienced and know what language to put in your divorce decree. So you got to have the family law lawyer who knows how to phrase those things so that it doesn't become an issue in the future, because you're going to have to share that divorce decree with the Social Security Administration if you're applying for your child to get SSI or other benefits. So they're going to look at that and see where that money is going, make sure that child then does not have money in their name, and that's what the trust is for. So you want to work with a special needs focused estate planning attorney and financial organization like Consolidated to make sure that that's done correctly before it's in the decree.
Does the court have to require child support for the special needs child? What if the parent doesn't need it? I mean, courts don't have to do.
Well, they don't have to do it. And, you know, there's a saying in the law that the plaintiff is the master of her own complaint, right? So you ask the judge to weigh in on what you want the judge to weigh in on. Now, if you decide not to get that finding, that potentially could be problematic in the future, depending upon the circumstances, how old the child is, and that sort of thing. So, but sometimes the child is too young, and we'll get to this in the slides. But at the end of the day, you just want to do what's in the best interest of your child and work backwards from that. And,
right,
and there was a question earlier, well, can we just go to a mediator without our attorney? And Mary Ann sort of alluded to this earlier, but I mean, the mediator is not there to advocate for you. And so the mediator she's not supposed to. She's supposed to be a neutral, in which case you have to have somebody in your corner. And you probably want an attorney, right? I mean, I always joke with people that, I don't tell my surgeon how to sharpen his scalpel, right? We know the first thing. I mean, I can go on WebMD and look some stuff up, right? But that's no substitute for knowledge and experience. But let's talk a little bit about how a child's disability can impact a divorce in the state of Texas. It can impact the property division. A lot of times people look to the sort of the default as an equal division of the community estate. But if you have one parent who's the primary caretaker of the child with special needs, then that could potentially impact the property division. It can impact the amount of child support, right? And again, and this is something that people sometimes are shocked to learn, is that Texas is different from New York and California in a lot of respects. And one of those respects is its child support laws. And child support in Texas is not about lifestyle. The law on that is very, very clear. It is about the needs of the child. And so you have to frame everything that you're seeking in terms of monetary recovery and the needs of the child. So, for example, private school tuition. There's at least one case out there that says you can be ordered to pay private school tuition as additional child support. But that's because, and that wasn't even a case involving a child with special needs. That was a case involving other considerations. But the moral of the story there is that if that person had gone in saying, well, my child's going to be, it's different when we're divorced, there's less stuff to go around, we really just want to keep it the same for the child. You have to be able to frame that in a need for the child, not a want. And we'll get to this in a little bit, but the Texas Family Code has something called an adult disabled child. This is a child who's incapable of self-support as a result of a disability that was known prior to the child turning 18. And if you can meet that threshold, then normally child support cuts off once the child turns 18 and graduates from high school. But if you have an adult disabled finding, and only if you have an adult disabled child finding, can you have child support go beyond that time period? Potentially, you're looking at how much time a parent has with the child. Sometimes children with special needs have very pressing medical issues. And that can, a lot of times people just default to what is called standard possession order, which is, basically every other weekend, right? So if you know anyone who's kind of gone through this process, there's a pretty good chance that it's technically first, third, and fifth weekends, but there are only a couple of fifth weekends in the year. So kind of speaking informally here, but But it potentially you're looking at a different parenting plan in terms of what possession and access of the child looks like. Decision making regarding the child, this is a huge one right here, right? Because a lot of times people are going to be looking to guardianship in the future, right? And to a certain extent, the family courts and the probate courts share jurisdiction on some issues. And sometimes they have things that they control differently, right? And sometimes that can get real nuanced real quick. And it also kind of depends on where you are, right? If you live in Austin, there is a probate court judge who was taken up all the way to the Texas Supreme Court because he wanted to grant a divorce in the context of a guardianship, and he did not want to defer to the family court. And one side didn't like that. In Houston, the probate judges generally don't like to get involved with what they've rightly or wrongly perceive as family law matters. And so they will defer to the family court system. So it really just kind of depends on where you are. You have the potential for what the state of Texas calls spousal maintenance, which is a little different than alimony, but it's the closest thing Texas has to alimony that can be ordered by a judge, which is different from the parties agreeing to it, right? We're talking about if the parties can't agree, because roughly 10% of cases do not settle, right? And so when you are looking at a case that does not settle, you have a different toolkit, right? In some respects, it's way less flexible. And then lastly, and Mary Ann kind of touched upon this a little bit earlier, but you need the child support to go into a first party Medicaid payback trust. If you take away anything from this presentation today, that needs to be it. That the child support should not go directly to the person receiving the child support, because ultimately that can create problems down the road for your child's eligibility for certain benefits. If we could go to the next slide, please, Michelle.
Yeah, that could greatly impact their SSI benefits and other benefits.
Yeah, Medicaid eligibility, all kinds of things. There can be all kinds of collateral consequences that child support is not ordered to be paid into a trust. What is an adult disabled child? Well, the child, whether institutionalized or not, requires substantial care and personal supervision because of a mental or physical disability and will not be capable of self-support. And the disability exists, or the cause of the disability is known to exist on or before the 18th birthday of the child. So let's talk about this a little bit, because this almost becomes estate planning by other means sometimes, and sometimes it's coercive estate planning. You know, if you have one parent who's the primary wage earner and they're either in denial about the child's disability or they don't agree with the extent of the child's disability, they might want to fight that, right? Or maybe they want to move on and you know, with their romantic partner, and then you're looking at, you know, as the primary caregiver of the child, you're looking at, well, how do I make sure that my child is taken care of after the divorce, right? And this is one of the ways you do that, is you have a child support obligation for an indefinite period, which means as long as the child is alive. And that means even if the person paying for child support dies, right? Because there is a way, there are a couple of different ways to make sure that the estate pays for that, right? Because, and that's a very important thing to remember. And then lastly, well, what does it mean to be able to take care of yourself? There have been a couple of cases where the child with special needs was not only a graduate of high school, but was going to college or was on track to get a college degree. I double checked in getting ready for today's presentation to see this morning if there have been any other cases out recently that have been released by the appellate courts about that, right? Because the appellate courts their opinions are what guide the advice your lawyer gives as you're in the trial court phase, right? Which is the phase that the vast majority of cases are. And The most recent case I could find was at the end of 2022, and that was a person, and it was a dad, which, you know, and sometimes it's the dad's taking care of the child. You know, that happens from time to time, you know, and but it was a situation where that person didn't want to pay any more child support, and they said, well, the child's going to college. What do you mean I have to still pay child support? They can, and the trial court found and the appellate court affirmed that just because this child was going to have a college degree, they still had a lot of physical challenges that prevented that person from, even if they could get a job, being able to support themselves, right? And that's probably the second biggest takeaway that I would want anyone watching this presentation to walk away from, is that the one, aside from duration, the second fundamental difference between child support for a child with special needs and a child that does not have special needs is that when you have a child with special needs, you can expressly consider future needs, right? So you're looking at almost like a life care plan, like you would in a personal injury lawsuit, for example, right? Because sometimes, I mean, I've had cases in the past where there had been an accident and a lawsuit, and when the parents had filed a lawsuit on behalf of the child, part of their personal injury legal team put together what's called a life care plan. They went out and they got a professional to say, you know, you're going to need ABC care, or the doctors say you're going to need ABC care, and it's going to cost XYZ dollars, right? Well, you can do that in a child support matter where the child has special needs, because it can help educate the court or the other side, if you're still working hard on trying to get a settlement, to show what this future needs of the child will be. If we go to the next slide, please, Michelle. Okay. So what if the child is under 18 and it's too soon to tell, right? You have a child who's maybe 7 or 8 years old, he or she's on the spectrum, and you're just not sure what interventions are going to work. You're not going to, I mean, who knows what's going to happen? Is the child going to be self-supported, right? Well, you can still use that as a factor for above guideline child support. And so family law in Texas, people by statute default to a lot of rules of thumb. And one of those rules of thumb is guideline child support. So you have X number of kids, say 2, right? And you start off at 1, it's 20%, 2 is 25%. And you apply that to the net resources of the person responsible for paying child support. That person's called the obligor. And net resources, in a very sort of bullet point understanding, is what you make after taxes, right? So before you make contributions to retirement, but what you make after taxes. And it caps out at around $9,500 a month after taxes, okay? If you need to go above that amount, right, or if you need to go above that percentage, this is how the child's medical issues can inform that process. And that, in my opinion, is where a lot of lawyers leave money on the table, right? Because they just do guideline child support. Now, sometimes people have enough resources in the marital estate, they don't want to litigate that for whatever reason. And that is sort of one of the curious things about family law, is that, you know, you look at a lot of litigation, take the personal injury lawsuit that we talked about earlier. You're not going to have any dealings with that trucking company or hospital again, right? But you're always going to have to deal with the other parent, even if it's on a minimal basis. I mean, you're always going to have that connection, right? And so sometimes people make a business decision that they're not going to avail themselves of everything under the law, and that's totally okay. But it's just something that you need to think about. And if you're talking with a lawyer and you're trying to figure out, well, who am I going to get to represent me? That's a good question to ask. What happens if the child's too young? And just in general, what are my options, right? I mean, that's just a good way to screen for that. Okay. How is the amount of support determined? In a nutshell, it's the needs of the child, right? I mean, that's really what you look at, present needs and future needs. And depending on certain things, You're either going to look at a 3-factor test or a 15-factor test. But just know that at the end of the day, it's really the needs of the child. If we could go to the next slide, please, Michelle. Okay, so these are some of the factors that the court can consider in determining the needs, right? And they look at the financial resources available, right? And so that they look at governmental benefits, right? They look to see if one of the parents is receiving governmental benefits, right? And that I've seen that issue come up where, because the child is older, one of the parents is looking to file for Medicare at some point, right? And there are some potentially collateral consequences of one child if a parent gets Medicare before the child does. Can we set guardianship in a final divorce decree when the child is 13? Depending upon where you are, each jurisdiction in Texas can be very convoluted, but as a general proposition, the court that hears the divorce is not going to be the court that hears the guardianship, right? You're going to be in two different courts. And a lot of times, even when people are divorced, they can be co-guardians of the child, right? That is a possibility. Now, the moment that they start disagreeing, then it becomes problematic, right? And I mean, there was a case that came out within the last 2 years where mom made some allegations that the child was being abused by one of the caregivers, including the other parent. And ultimately, the parent alleging the abuse, it turned out to be intentionally false allegations. And so that parent was no longer the co-guardian. And it was really interesting from a legal perspective because they basically got the lawyer from APS to provide expert testimony on some of that in a sort of a backdoor kind of way, which I thought was kind of interesting. But in any event, so these are the factors that you look at, right? And again, any existing or future needs, and we've talked about that. But if we go to the next slide, please, Michelle. Yeah. Possession and access to an adult disabled child. All right, this is important. This goes back to where you have the probate court that can decide things because they have the guardianship, but they also can be decided in the family court. And sometimes you're doing things in one court to impact the outcome in the other court. I've been involved in cases where I knew that the bad actor parent was going to try something in probate court later on. And so you try to get findings that will be helpful to you when you know that the second round of litigation is going to open up. Now, let's talk a little bit about what else the family court can decide. They can decide possession and access. They can decide child support. It's kind of an open question as to what else they can decide, especially if there is a probate court that has guardianship jurisdiction. On one hand, a lot of lawyers say that the family court really can't decide much else. I don't know that. I think you could read the statute either way, right? And that's one of the things about family law matters involving children with special needs is that some of it's very murky. It's very murky. And in fact, one of the cases that came out within the last 4 or 5 years, and this was down in South Texas, the obligor for the child support payment was trying to terminate his child support obligation. So the kid was getting ready to graduate from college. Kid will be able to work once the child graduates from college. The trial court didn't agree, went up to the Court of Appeals. Court of Appeals affirmed it. And it was the Corpus Christi Court of Appeals. And that's the court that, frankly, is a lot of times, the Texas Supreme Court probably reverses that court more than any other. Or at least that was historically true. So the father appealed it again to the Texas Supreme Court. And the Texas Supreme Court didn't hear the case, but there's a justice and one of the few former family court judges who's ever served on the Texas Supreme Court, right? Only like 3 or 4 in the history of the state of Texas. Only 3 or 4 family court judges have served on the Texas Supreme Court. And she said, look, we're not taking this case, but we really ought to take a case like this sometime soon because this statute is really, really unclear. Like if I get a disability finding, can someone come back and say, well, the child's no longer disabled, right? Or is that disability finding always there and the trial court just has to say that the child support obligation is 0, right? And so it was Justice Guzman, and she went through some of the questions that she thought were kind of unresolved in the statute.
Yeah, there's a lot of questions about guardianship, and what if you already have one parent already has guardianship, or the parents already have guardianship over their child and now they're getting divorced? That's what you're saying really, is that they can just,
Well, sometimes I can streamline things, right? Sometimes it can make things more complicated, right? Because it depends on whether or not the parents are fighting or there's conflict about access to the child or making decisions about the child, right?
and if one parent knows more about the child and their disabilities and has served mainly as a caregiver, and now they're getting divorced and the other parent wants to get more involved all of a sudden, but doesn't really
Right.
know.
That's exactly right. And, you know, and Mary Ann kind of alluded to some of this earlier in her presentation, but when people go through the divorce process, right, there's a lot of trauma, a lot of unresolved trauma that can come to the forefront of things. And trauma is it's a curious thing. It can take matters that should be pretty straightforward legally, and people really aren't arguing about legal things. They're arguing about emotional things, right? And that in no way minimizes it or discounts it, but it make it less important. But it's important, you know, because some lawyers will fuel the fire, right? Because they make more money that way. I hate to sound cynical, right? But that has happened, right? And there's also this, I think at this point in time, it's pretty pronounced, but there's a tendency for people to seek out their own personalities in their lawyers, right? So if someone is not very agreeable, they might just find themselves, surprise, surprise, a lawyer who's not very agreeable, right? And sometimes the shoe goes on the other foot. And then sometimes people are like, well, I need a bulldog. I need someone who's going to go fight for me. You know, and there's something to be said for that. What you really want, though, is you want a lawyer who's going to be effective, right? And some lawyers are good at lots of different things, and some lawyers are only good at fighting or only good at not fighting, right? And so one of the things that when you're talking to potential lawyers, is ask them how many cases that they take that go to trial. And if they take a case, if they have a couple of cases a year that go to trial, that's a good sign that they're willing to go to court, but they're not making it all of their cases go to court, right? Because some lawyers have a lot more cases go to trial, right? For whatever reason. And you do want a lawyer who can kind of narrow the issues for you if that's possible. And so let's talk about, again, how's the amount of support determined? And this kind of looks to a couple of things. Then this is really about spousal maintenance, right? This is Texas's version of alimony, for lack of a better term, that's not agreed upon. And so you're looking at really the same sort of statutory criterion for an adult disabled child. Now, for child support purposes, here is another pointer on when you're interviewing prospective attorneys. Ask them about Chapter 8 and ask them, how much money if I'm the primary caretaker of a child with special needs, how much money do I have to get before I have too much money to qualify for this statute? And a lot of lawyers think that if you get a couple of $100,000, then that's it. You're not going to qualify for this statute. And I can tell you, especially within the last couple of years, there is a pronounced trend in the appellate courts in various parts of the state where people are getting as much as $750,000 in their divorce award and still qualifying for Chapter 8 spousal maintenance. All right. And that's very important. And there's this notion that people shouldn't have to spend down their assets, right? So it's not even just the amount of money, but it's the composition of the money. If the bulk of the estate of what someone's getting is in retirement, or if it's in a income stream, like you have one spouse that, you know, had a problem with gambling, going to strip clubs, romantic relationships outside the marriage that they spent money on, that people shouldn't have to spend down their assets or be kicked out of being eligible for this statute if they're getting some money, like some relief for stuff like that, but it's not a lot. And well, I won't say not a lot, but if you are getting less than $750,000, and again, it depends on each case, but you might still be eligible for Chapter 8 spousal payments. And that's just something to ask about when you're researching lawyers. Okay. What happens if somebody doesn't agree about whether or not a disability exists or the extent of the disability?
I
Well,
have
parents-
definitely been asked this question before. This
Yeah.
is a real thing.
Yeah. And so parents can testify, right? And there's a real interesting case in East Texas where they found the child wasn't disabled because when the child was living with one parent in a different state, the child was a lot less independent with that parent. And then the child started living with a different parent and was able to get a job and be more independent. And there was frankly just a different parenting dynamic, right? And the court found, well, you know what? If I might have made a different decision had the child not moved to Texas and started living with this other parent and got more independent, right? You can get medical experts to testify, but I will tell you, and this is one of the real interesting areas. This is another great question when you're interviewing prospective lawyers, is ask them about something called 104.008 and just see what they know. Because that is
104.00.
008. Yeah. Because that part of the family code has been changed several times over the years. And that is the part of the family code that regulates how experts can testify in family court and what they can testify about. And I had a week-long arbitration in February of 2023. And in January of 2023, the Dallas Court of Appeals came out with an opinion that it wasn't a special needs case, but it has bearings on special needs cases. One of the most foremost forensic psychologists in America was not allowed to testify as a rebuttal expert. And they changed 104.008 in large part because of that case, right? And so now you have a different iteration. That statute's been around, I want to say since 2015, and it's been changed 3 or 4 times at this point. And so I'm unaware of the newest version of the statute because the newest version of the statute did not become effective until September 1, 2023. But that is something else to be mindful of when you're interviewing lawyers. The last thing, or one of the last things also to be mindful of, and this is when you are getting the mediated settlement agreement or getting the relief that you're seeking put into a court orders. Texas is notorious in America for having some of the longest, most detailed divorce decrees in America. You can argue about whether or not that's a good thing or a bad thing, but when people have arguments about how something should be drafted in these 50-page divorce decrees, oftentimes they will rely on a document called the Texas Family Law Practice Manual. And it is sort of the Bible of how divorce decrees should be drafted in the state of Texas. And the people that put it together, it's a volunteer committee, and they do a really fantastic job. But, and there's always a but, right? Mm-hmm. Some of the standard language for medical support and health insurance, it's not drafted with the child with special needs in mind, right? The biggest problem is when people just sort of default to preferred provider language, right? Because, and what that means is that you're supposed to use a doctor in your insurance network, right? And then if you don't, then the person who took the child to the out-of-network provider or the non-preferred provider is responsible for 100% of the costs, right? Well, sometimes you have people that are not in network, right? And that's something to be mindful of. The other thing to be mindful of is how medical expenses define, right? Because again, the way that is defined by the Texas Family Law Practice Manual is it wasn't written with the child with special needs in mind. If we go to the next slide, please.
There you
Okay,
go.
there's my contact information. I know we're at 1 o'clock, so sorry we got right up to the time, but I am this is my contact information. I work in Houston. I'm happy to answer questions if anyone has a question later on, because I know we're out of time. And I just want to say thank you to Mary Ann, and thank you to Michelle, and thank you to Allison for this opportunity to speak. I've had the good fortune of speaking at a lot of these webinars, and it's something that I really enjoy. And I thank you for the opportunity to provide a service, or to be of service.
Thank you both so much for being here today, and everybody out there listening to us today. This screen I just wanted to put up for a moment. This we give you a free consultation at Consolidated Planning Group if you want to talk about the financial side of all of this. We're who you should call. The financial side, the benefits, the ABLE accounts, retirement planning, future cost of care estimates, life insurance, things like that. And we would love to speak with you about your needs. Of course, our contact information is here. You've received Mike's contact information and Mary Ann Hughes. You will receive all of these slides later in your email. And I hope you have a fantastic week. Please feel free to reach out to any of the three of us. We are here to help, and we welcome your calls. So thank you all very much. Thank you, Mike and Mary Ann. I hope everybody has a great week.
Thank you.
Bye-bye, everybody.